All rise. Veuillez vous lever. The International Residual Mechanism for Criminal Tribunals is now in session. L'audience du mécanisme international appelée à exercer les fonctions résiduelles des tribunaux pénals est ouverte. Please be seated. Veuillez vous asseoir.
Registrar, please, you can call.
Good morning, Madam President, Your Honors. This is case number MICT-12-17-R in the matter of the prosecutor versus Mr. Gérard Ntakirutimana, sitting today, the 22nd of November, 2024. Thank you, Your Honors.
Thank you, and good morning to all of you. I note that Mr. Ntakirutimana is not participating in these proceedings. It was decided he was going to do it via video conference, but he's not there. But the defense has indicated that they have no objections to proceed, so we will do it. And following this, I will ask you for the appearance of the parties, and we start with defense counsel. Please, for Mr. Ntakirutimana.
Oui, bonjour, Madame Présidente. Good morning, Madam President, Your Honors, Judge Wangogo, Michel Duradio, Pitva Rochelle, and myself to represent Ntakirutimana. I apologize for the absence, but there was a misunderstanding about the time.
So we will take note of that when he arrives. Thank you. And the prosecution, please.
Good morning, Your Honors. Laurel Beg for the prosecution. I'm joined by my colleague, Senior Trial Attorney Rashid, Legal Officer Christine Keller, and our Case Manager, Ms. Janet Stewart. And I'd just like to take 1 second to note on the record that this is likely to be Ms. Stewart's last day in court for the mechanism, and to congratulate her on 26 years of distinguished service with the ICTY and the mechanism. And prior to that, she had earlier service with the United Nations in the war zone in the former Yugoslavia. So I didn't want the day to go by without mentioning that and thanking her.
Thank you for mentioning that, and we can continue now. As publicly announced in court on 19 November 2024, the Appeals Chamber will now pronounce its review judgment orally. Written reasons for the judgment will follow later, and this procedure is provided for under Rule 122A and C of the Rules of Procedure and Evidence of the mechanism. Today's oral pronouncement is a summary of the central findings of the Appeals Chamber. The written judgment, when filed, will be the only authoritative version of the judgment. And before we begin, I want to reiterate my gratitude to everyone who made this hearing possible, including the parties, ITSS, interpretation, transcription, security, witness support, and many other colleagues. This case concerns Mr. Gérard Ntakirutimana's request for review of his convictions on the basis that prosecution witness H.H. recanted his trial testimony in the Ntakirutimana case before the International Criminal Tribunal for Rwanda. Witness H.H.'s testimony exclusively underpins Mr. Ntakirutimana's convictions related to events at Gidwe Hill near Gidwe Primary School in the late April or beginning of May 1994. Mr. Ntakirutimana was a medical doctor at the Seventh-day Adventist Hospital at Mugonero Complex in Gishita Commune, Kibuye Prefecture, Rwanda, between April 1993 and April 1994. During the trial proceedings in the ICTR, witness H.H. testified that he saw Mr. Ntakirutimana at Gidwe Hill on an unspecified day around the 8th of April or beginning of May 1994. The witness stated, in particular, that Mr. Ntakirutimana pursued and shot at Tutsi refugees during an attack at Gidwe Hill where the witness had taken refuge from the killings. On 21 February 2003, Trial Chamber 1 of the ICTR convicted him of genocide and murder as a crime against humanity. He was sentenced to 25 years of imprisonment. On 13 December 2004, the Appeals Chamber of the ICTR affirmed Mr. Ntakirutimana's convictions for committing genocide and murder as a crime against humanity, entered additional convictions for aiding and abetting genocide and extermination as a crime against humanity, and affirmed his sentence of 25 years of imprisonment. More than 10 years ago, on 26 March 2014, Mr. Ntakirutimana was granted early release by the president of the mechanism. On 14 December 2023, Mr. Ntakirutimana filed a motion to review the appeal judgment and his convictions. On 21 May 2024, this appeals chamber partially granted his request and found that witness H.H.'s purported recantations after the appeal judgment was issued constitute a new fact. The appeals chamber also considered that, if proved, this new fact could have been decisive in the original decision, as witness H.H.'s evidence exclusively underpins Mr. Ntakirutimana's convictions for aiding and abetting genocide and extermination in relation to an attack at Gidwe Hill near Gidwe Primary School in late April or early May 1994. The appeals chamber therefore considered that a review hearing would be held to allow the parties to present evidence concerning the new fact. On 18 September 2024, the appeals chamber scheduled the review hearing and, in doing so, only allowed Mr. Ntakirutimana to call witness H.H. to testify. The appeals chamber emphasized that the focus of the review hearing would be to test the credibility and reliability of witness H.H.'s purported recantations, and specifically in relation to events at Gidwe Hill near Gidwe Primary School. The review hearing took place on 18 and 19 November 2024. Following witness H.H.'s testimony, the appeals chamber heard oral submissions by the parties on whether Mr. Ntakirutimana had met his burden of proving the veracity of witness H.H.'s purported recantation. The history of witness H.H.'s recantation in the Ntakirutimana case began during proceedings against Jacques Mounouar-Herrere in Canada. In a meeting on 18 November 2011, witness H.H. met with Canadian prosecution and defense representatives in the Mounouar-Herrere case and stated that he has falsely accused Jacques Mounouar-Herrere. When asked by Jacques Mounouar-Herrere's defense counsel about his testimony at the ICTR, the witness confirmed that his testimony against Mr. Ntakirutimana was true and he did not lie. In a statement provided to the defense in the Mounouar-Herrere case dated 3 December 2011, the witness stated that he testified against Mr. Ntakirutimana a long time ago, that he had not seen Mr. Ntakirutimana shoot anyone, and that his ICTR testimony did not reflect the truth. However, at an interview on 13 February 2012 in relation to the Mounouar-Herrere case, witness H.H. confirmed his ICTR testimony against Mr. Ntakirutimana. In October and November 2012, witness H.H. testified before the Canadian court in the Mounouar-Herrere case. During those proceedings, he stated that he did not tell the truth at the ICTR, that he had falsely accused Mr. Ntakirutimana and his father, and he did so out of anger and revenge, that he associated Mr. Ntakirutimana to acts of other attackers to make his testimony more plausible, and that he wanted vengeance against Hutus until his release from prison in 2011. the Canadian judge found his testimony very credible. Witness H.H. also made a statement on 18 November 2013 in relation to domestic proceedings in the United Kingdom. He confirmed the recantation of his testimony against Mr. Ntakirutimana before the ICTR. According to witness H.H., he decided to tell the truth after being imprisoned in 2011 on false murder allegations, and did so despite risks to himself. A month later, on 18 December 2013, Mr. Ntakirutimana filed a motion before the mechanism requesting assignment of an amicus curiae to investigate witness H.H. for having provided false testimony in the Ntakirutimana case. The matter was assigned to a single judge on 7 February 2014. On 2 March 2016, the single judge found that strong grounds existed for believing that witness H.H. knowingly and willfully gave false testimony in the Ntakirutimana case and referred the matter to the president of the mechanism, who then, in accordance with the rules, assigned another single judge to determine whether to initiate false testimony proceedings against the witness. On 13 June 2016, the single judge ordered the appointment of an amicus curiae to investigate whether witness H.H. gave false testimony in the Ntakirutimana case, as well as whether witness H.H.'s recantation in Canada was fabricated. The amicus curiae was appointed on 10 October 2016. In his investigations, the amicus curiae considered extensive documentary evidence and interviewed representatives of the Canadian prosecution and defense in the Moonwater case, as well as witness H.H. In an interview with the amicus curiae on 9 May 2017, witness H.H. confirmed that he recanted his testimony against Mr. Ntakirutimana. The amicus curiae concluded his investigations on 28 August 2017. The amicus curiae observed that witness H.H. was consistent in his explanations for falsely accusing Mr. Ntakirutimana and for deciding to recant. The amicus curiae concluded that witness H.H. knowingly and willfully provided false testimony before the ICTR in the Ntakirutimana case, and that there were sufficient grounds to initiate false testimonies proceedings against him. The amicus curiae also concluded that the recantation of his testimony against Mr. Ntakirutimana was not fabricated. On 20 November 2017, the single judge issued a decision observing that witness H.H. expressly recanted his testimony against Mr. Ntakirutimana and that sufficient grounds existed to initiate false testimony proceedings against the witness. However, the totality of the circumstances weighed against initiating such proceedings, and the case was terminated. The single judge further stated that declining to proceed against witness H.H. did not prevent Mr. Ntakirutimana from seeking review of his convictions in light of the witness recantation. On 17 November 2019, witness H.H. was interviewed by Mr. Ntakirutimana's defense team. Witness H.H. stated that, among other things, his ICTR testimony against Mr. Ntakirutimana, including events at Jidwe Hill, were false. In a statement dated 18 and 19 November 2019 to Mr. Ntakirutimana's defense team, witness H.H. confirmed his recantation. In his testimony at the review hearing, witness H.H. acknowledged that during the Ntakirutimana trial, he testified that Mr. Ntakirutimana was among the attackers at Jidwe Hill and that Mr. Ntakirutimana had shot at a man named Estras. Witness HH stated that his trial testimony was false and that he never saw Mr. Ntakirutimana during the attack on the hill. Witness HH explained that he gave this testimony because, and start quotes, the genocide made us offer a great deal as Tutsis whose families were exterminated by the Hutus, end of quoting. As a survivor who felt angry, witness HH stated that he saw providing false testimony as an opportunity to take revenge against Hutus. According to witness HH, he was imprisoned between January and April 2011 after being falsely accused of murder. Witness HH testified that during this time he suffered a great deal and felt isolated as he was imprisoned with other Hutus who he had testified against in Gacaca proceedings. According to witness HH, he prayed, and God spoke to him and told him that his sentence was nothing in comparison to the people he had testified against who died in prison. Witness HH continued that he heard a voice asking him, start quoting, if justice was rendered in your regard, what would you do in your turn? End of quote. Witness HH stated that he told the voice, start quoting, if I lie against anyone, that if that person died, I will ask for forgiveness from God. If I testified falsely against someone who is still in detention, I promise not to do this again, end of quote. Witness HH testified that at some point after this experience, the public prosecutor dropped the charges against him and that he was released. According to witness HH, after leaving prison, he felt weak because of his false testimony and decided to begin recanting his prior testimony in a court setting. The defense submits that witness HH's recantation is genuine and that, among other things, there is no credible evidence on the record showing that the witness had been corrupted during the process where he retracted his testimony in this or other cases. The defense also highlights that his evidence was found credible by a Canadian court in the Mungwarere case, where he also retracted prior incriminating statements, and that the amicus curiae determined that there was a sufficient basis to prosecute him for false testimony after a thorough investigation. The prosecution submits that, among other things, witness HH's recantation is neither credible nor reliable, that it is the product of incentives and manipulation, and that his evidence is insufficient to meet the high threshold for reversing a final judgment. The prosecution also requested more time to investigate the recantation. At the outset, the prosecution's suggestion that it should be given more time to investigate witness HH's recantation is without merit. The prosecution has been aware of the allegation that witness HH recanted since at least December 2013, when Mr. Ntakirutimana requested the mechanism to investigate witness HH for false testimony. Additionally, in 2018, Mr. Ntakirutimana was assigned counsel to assist him in the preparation of a review application on the basis of a finding that there was a sufficient basis to initiate a prosecution for false testimony. The appeals chamber further notes that since the scheduling order of the review hearing, the prosecution has not sought extensions of time or to postpone the hearing. The fact that the prosecution waited until the last minute to begin its investigation is not a reasonable basis to prevent reaching finality in these proceedings. Turning to the central issue before us, the appeals chamber has carefully examined witness HH's testimony and the circumstances surrounding his recantation. The rationale behind his decision to testify falsely and then to later recant on its face appears plausible. The appeals chamber can, therefore, fully understand why the amicus curiae in this case determined that there was a prima facie case for instituting proceedings for false testimony against witness HH. However, accepting that witness H.H.'s recantation is indeed false, and as a result, overturning a final conviction demands a much higher threshold of scrutiny. The Appeals Chamber finds particularly troubling that on 18 November 2011, when witness H.H. was interviewed by a Canadian prosecutor and defense lawyer about his testimony against Mr. Ntakirutimana, he affirmed that his testimony in the Ntakirutimana case was true. This was just a few months after his religious experience in prison. This is particularly surprising as, during this interview, witness H.H. retracted prior incriminating statements against Jacques Mungwarerere, based on his promise not to lie again and to tell the truth. When questioned on this point during the review hearing, witness H.H. did not provide a reasonable explanation about why he did not recount his testimony during the interview. His answers were notably evasive. The Appeals Chamber further observes that witness H.H. did not consistently affirm his recantation after this point. As previously mentioned, he informed the defense in the Mungwarerere case during an interview on 3 December 2011 that his testimony against Mr. Ntakirutimana before the ICTR was not truthful, but in a subsequent interview in February 2012, confirmed his ICTR testimony against Mr. Ntakirutimana. The Appeals Chamber is mindful that witness H.H. would subsequently go on to consistently affirm that his testimony in this case was false and that he ever maintained this position under threat of prosecution. Nonetheless, bearing in mind this powerful account of why he began recanting, the Appeals Chamber considers that his response affirming his testimony in the Ntakirutimana case during the November 2011 interview raises considerable doubts about the truthfulness and as to why he decided to recant in this case, and serious questions about the veracity of his recantation itself. In this respect, the Appeals Chamber notes that witness H.H. acknowledged truthfully testifying against other ICTR accused persons, reflecting that he took his oath before the ICTR seriously at the relevant time when he testified in this case. Other circumstances surrounding witness H.H.'s recantation are also noteworthy. This includes his close ties with Jacques Mungwarerere's brother, Gérard Ntakirutimana, and in particular, his admission to receiving a few payments from Gérard Ntakirutimana and his wife. These payments are not necessarily significant sums, and the evidence does not demonstrate that he was paid to give false testimony specifically. Importantly, however, the Appeals Chamber notes that the witness expressly confirmed that he never received payments from Gérard Ntakirutimana or his wife. It was only after the prosecution indicated that it had proof of payments that the witness acknowledged this fact. He stated, start quoting, "I didn't know that you had these transcripts of these transactions," end of quote. This raises questions about his candor on a sensitive topic. Witness H.H. was also charged with Gérard Ntakirutimana and others who all shared the same lawyer for bribery in connection with the conduct of the Mungwarerere case. Although the witness was acquitted, he did acknowledge being aware of information that some witnesses were receiving money from Jacques Mungwarerere's family. Although not decisive, this raises some additional concerns about the context in which he began recanting his testimonies in various cases, including this one, which began during the Mungwarerere case. In view of the foregoing, the Appeals Chamber is not satisfied that the defense has shown that witness H.H.'s recantation is sufficiently credible to prove that the witness falsely testified against him during the Ntakirutimana trial. The Appeals Chamber notes, in particular, his affirmation of telling the truth against Mr. Ntakirutimana during the November 2011 interview, and his subsequent inconsistent positions in December 2011 and February 2012 as to whether he recanted his ICTR testimony. The appeals chamber recalls that the review proceedings were authorized to test the veracity of witness H.H.'s purported recantations. For the reasons already discussed, the appeals chamber finds that Mr. Ntakirutimana has failed to prove the new fact that witness H.H. truthfully recanted his testimony in the Ntakirutimana case before the ICTR. The evidence provided at the review hearing equally raises questions about witness H.H.'s credibility. However, the appeals chamber would not lightly disturb a trial chamber's assessment, which was subject to appeal, based on witness H.H.'s subsequent conduct that occurred more than 10 years after his original testimony. Accordingly, the appeals chamber, pursuant to to Article 24 of the Statute of the Mechanism and Rule 147 of the Rules, unanimously finds that Mr. Ntakirutimana has failed to prove the new fact. Judge Antonetti will append a concurring opinion to the written judgment, and with this brings the review proceedings to a close. The written reasons for the judgment will be filed as soon as possible, and the appeals chamber will now rise.
All rise. We have 11.